chat. Hello. It's Friday night. It's Friday. It's Friday. Oh boy, it's Friday. Guys, so we have some interesting stuff. We were gonna do just the Karen Reed reading the motion to get Turtle Boy the text um to compel the screening of seized devices from Turtle Boy's thing, and mainly because there's an entire issue of discussions between allegedly him, Yanetti, and Karen Reed, that they were using this to communicate, and therefore um, they can go into all these documents and they can go into all these text messages, and they're not protected by attorney-client privilege. There's a bunch going on there. But today there was a hearing set where Hank Brennan showed up, and I know Bob Mata over on Defense Diaries started covering this, and somebody texted me, and I was in the middle of a hearing, and I'm like, what? And while we were waiting for the hearing to start, I flicked over, and I'm like, holy shit, they're all in court. What's going on? So this is another issue regarding not only Karen Reed's case, but Turtle Boy's case. This is where they cross over. So we're going to get to this. It's not very long. It's not very long. It's only like, it's just a little bit of time, but it's something worth taking a look at. So hold on here. He just knows I'm at 25.2. Yes. Yes. Bella, this is an issue about and you're gonna see Hank Brennan kind of has a bit of a moment here. From what I've been told, Hank Brennan kind of steps all over his dick here with the judge. So Karen, what are you talking about, man? How you doing? Biologists are up in arms about the catfish and their beloved stupid blue crabs. Why do you hate blue crabs? Are amazing food. They are so good. Oh my god. I like it better than, like regular crabs. I think they're very good crabs. They're very good eats. So let's see here. You're saying catfish have been blamed for eating all the crabs. The irony is the bigger catfish eat anything. And the second favorite fish here, the striper, is eating all the crabs. Ooh, that sucks. The stripers are eating all the crabs because stripers are good eating too. So, yeah. Botto says, good evening. Time to suffer. Well, hopefully you have a quiet night tonight, man. There we go. You say you'll post a video on Locals later about some preliminary info. It's a very interesting study. Oh, cool. You live 20 miles from the best blue catfishing spot in all the United States. Well, there's nothing wrong with good catfish, especially good fried catfish. So, did you guys miss Clyde? Not yet. Not yet. And no, guys, this is not Bev. This is the Turtle Boy judge. This is not Judge Canoni today. Where's your fish sandwich, fat man? I don't know. Where's your mom at? I don't know. She's not here tonight. Oh. Karen says blue crabs suck. What? Why? What are they? There's nothing wrong with them. They're the best. I mean, like for the price, they're better than trying to get king crabs and snow crabs. Like those are all good. But overall, like if you're in the Chesapeake area, the blue crabs are amazing, and yeah, I don't think they're a bad deal at all. I think they're pretty good for what they are. James says, "What about?" I didn't know he said anything about me, so I don't know. I mean, like, okay, I don't know. I didn't know there was any issue there, so don't think you've ever had blue crabs. Yes. Where's best boy Clyde? I don't know. Let me see if I can get him here. He was seething about us in legal mindset. I didn't even know he was doing that. Nobody tells me this stuff, so I don't know. Like you're like asking me what happened to, it's like asking me about the the weather forecast in, Tashkent yesterday. I'm like, oh, nobody told me about it. Hold on. Hey, Clyde. Come here, Bubba. Let me see if he's Clyde. Clyde. 2.0 wasn't feeling good tonight, so she had an early night. I think he's laying down with her because he normally would be here by now, but I think he's all snuggled up. So I don't know where Clyde is at. It's Lent. Did you sinners get fish? No, I messed up today. So I messed up. There's a fishing tournament here for stripers. Ooh. That would be a lot of fun. Oh, he's not Turtle Boy's judge. I'm sorry, you're right. It's a different judge, but it's not Judge Cannoni today. So, and what I understand, this is actually the way this judge is handling it. I think Bob explained it to me. It's because they're dealing with issues of the privileged communications, that this is a different judge answering those issues. So my apologies there, guys. Whiskey says, your mom's over here. I won't keep her out late. No. Bella's saying, yeah, at least Stefanik, that something happened there. Something happened there. It's weird. She gave up her UN ambassadorship, which I don't mind. I'm all happy about it because we don't need any more Israel toadies out there. Like Israel's, at least Stefanik, she call her, Israel Stefanik. We don't need any more yay Israel people. Like, we don't need that. No more Israel stands. So her not being there is better. I don't know. Fuck it. Like, I don't know something happened. So, oh well. If Alyssa clipped it, it didn't happen. Yeah, that's how I do it. How about Pisco versus Joe? I didn't get a chance to see it. I'm sure it's interesting. I'm sure it was very interesting. Did I see the cop that slapped the Saudi diplomat? No. Put that shit on locals. I want to see this. When's the next sandwich? Please speak in the Clyde voice when he's here. I will, of course. Yes, Clyde had his beauty day today. He did. He got a nice old haircut. Let me see something. I'll try this. We'll use the Kimbo's Clyde treats. We'll see if the Clyde vitamins will work. I hear click-clacks. Fast ones. He's coming. He's coming in hot, chat. Come here, buddy. Come on. Everybody wants to see you, buddy. Come on. Oh, there you go. Well, chat, there you go. He's a good-looking boy today. Look at him. See? All you guys were saying he's fat or he's chonky. No, he could actually say it's just his fur. He's big-furred. There you go, Bubba. And Lainey got trimmed up today, too. I'll see if we can get pictures of her. We'll put them on locals. But Lainey got a nice little haircut. But Clyde got a haircut. And, oh, he smells so good right now, chat. Oh, yes, he smells good. He hasn't rolled around in pee or anything else right now. So, Hi, Bubba Bear. Hi, Clyde. Clyde the dog. Woof, 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 woof. He's like, yes, fat man. Oh, yes, fat man. That is hitting the spot. He's like, danke, fat man. He's like, danke. He's like, oh, am I getting you there, good buddy, huh? He's like knocking me over the chair. Oh, yeah. That's the thing 2.0 I said. This is like his scratch button. If you hit it, he's just like, oh. Oh. Hi, buddy. Oh, yeah. He's just a big lovely doggy tonight. Does attorney-client privilege stay in place post-death of the client? Yes. Yes, if the client never waives it, you can't breach it. Now, once again, there are limited times where an attorney is allowed to breach attorney-client privilege, in particular to defend themselves. For example, like if the client accuses you of doing something, you could say, no, that's not what we talked about. There are limited times you can breach attorney-client privilege in that regard. But yes, otherwise, if one of you, like, for example, Jason, if you're my client, and we sit down to talk, and after you talk and we're sitting in the office, you get hit by a bus, that privilege is there forever. because you haven't waived it. So if somebody asked me what we talked about, I'd say can't tell you. Now, if there's a situation where like your estate tries to sue me and says I did something or didn't do something, I would say, look, here's all we talked about. But otherwise, yes, the attorney-client privilege is the client's and it follows him to the grave. So, and I have had clients who have died. So their secrets, whatever they said is now secret forever. I gotta sit you down, Bubba Bear, but everybody gets to see your little bandana. He got a little Easter bandana too, so he's a good boy. So there we go. All right. Tech Guy says messed up. You had no intention, did you, Sean? Shh. Tennessee's put a big hurt on Kentucky, yeah. Yes, Joe Key got scared and they were losing the Florida special elections. I think that's actually probably the answer. So, yeah. So let's see here. Alex Jones for UN ambassador. Yeah. Kimbo's MIA. Hope he's good. From what I understand, he's doing okay right now. So we are going to get started here, guys. It's about time. Yes, Clyde looks so good. He does. Mm-hmm. Very good. Says the cult of Clyde. Yes, some of these districts, Trump has won by 30 points. So if they lose it, then they let them steal it. Yes. Unit Bite's really noticeable the short hair. Yes, it is. The Clyde stocks are going up. All right, guys. So it is time here. Hold on. Say Haven Cake says, but do you have to tell if they said they'll be committing a crime in the future, right? Nope. Here we'll talk about this. Ohio professional rules. Okay, we'll open this up here because this is important. This is truly important here. Okay, so we are going to open this up and we're going to do a little bit of light reading, chat. All right. So this is the Ohio Rules of Professional Conduct from the Supreme Court of Ohio, filed September 2021. They have not changed them since then. So it talks about confidentiality, Rule 1.6. So real quick, chat, we're just going to blow through this here, okay? It says a lawyer shall not may reveal information relating to representation of a client, including information protected by attorney-client privilege under applicable law unless the client gives informed consent. That also includes if somebody says, hey, are you representing them? Technically, that's protected too. Now, for example, though, if opposing parties or a lawyer says, hey, are you representing this party? That's actually like you kind of like have to be a little courteous there and work that out. The disclosure is impliedly authorized in order to carry out representation, or the disclosure is permitted in Division B or required under Division D. So there's times where it's implied that I can discuss things. So now notice here, you're saying, do I have to do it? Well, here's the thing. A lawyer may, and this is the critical thing here. A lawyer may reveal. I don't have to. It's discretionary. And I don't have to relay any information, but I can to the extent it reasonably believes necessary for any of the following purposes. To prevent certain death or substantial bodily harm. To prevent the commission of a crime by the client or another person. To mitigate substantial injury to the interest and property of another resulting from their commission of an illegal or fraudulent act in which they've used my services. To secure legal advice about compliance with the rules. Now, that one happens all the time. Lawyers will say, hey, man, I got a question. What do you think I should do here? And this happens all the time. So this one actually happens a lot. Lawyers talk all the time to each other. To establish a claim or defense on behalf of the lawyer in a controversy between the lawyer and client. So, for example, if there's a bar dispute. To establish a defense to a criminal charge or claim against the lawyer based upon conduct in which the client was involved. So if I get accused of being in a conspiracy with you because you committed a crime and you said I did it, I could say, no, I didn't. We didn't talk about that. I'm allowed to defend myself. Or to respond to allegations in any proceeding, including disciplinary matters concerning representation. I'm allowed to defend myself. To comply with other laws or court orders. There might be times where you have to disclose things. To detect and resolve conflicts of interest arising from the lawyer's change of employment or from changes in the composition or ownership of a firm. So there's times where I may have to reveal information to figure out if there's a conflict of interest out there, but only as necessary and only if it doesn't compromise the attorney-client privilege or otherwise prejudice the client. So you have to avoid those things. But notice this is may, meaning I don't have to. If you told me tomorrow you're going to go baptize pull an Adam Lanza and baptize a bunch of kindergartners, I don't have to say shit to nobody. I could just sit in my office and play Sudoku. I could go tell someone. Don't have to. The only time I've had people tell me they were going to go commit crimes. I didn't get involved. The only time I've ever really gotten involved is if somebody said they were going to hurt themselves. Because I don't want anybody to hurt themselves. But otherwise, it's not my fucking problem. Now, D is where I shall, meaning I have to. Part D means I have to reveal information if I need to. And it's relating to Rule 3.3 or 4.1. So what are those two rules? Well, Rule 3.3 is candor towards the tribunal. So if you start defrauding the court or committing a fraud upon the court, I have a duty to prevent that. So I can't let that happen. And then Rule 4.1 is truthfulness in statements to others. Privilege doesn't allow me to let you lie and defraud other people. So those are the limitations. You like how my beard matches Clyde's? Yes. Where's Cedar Rose? Yeah, I wonder where she's been in a little while. So I'm not sure. Manny B, you're saying, okay, hold on. So someone says, speak to my lawyer. Do you have to say who the lawyer is because they can't say so? Well, generally speaking, they're allowed to ask for this. If an attorney comes and talks to me and says, hey, are you representing Maddie B? I could say yes. Because obviously, he'll say, I represent J-Rock. I'm like, okay, cool. So there's times where I will say so, but just in general, there was something in here where I was representing people on a matter. People kept asking me about it, and I said, I can't tell you about it. Can't talk about it. Don't talk about pending cases. I didn't talk about it till other people had confirmed things. I don't discuss, if you can avoid discussing things, you do. Island, how you doing? I have a duty. Yes. So lawyers are against lying when it's to the court. Otherwise, I don't care. And other parties. Siobhan saying, oh, wow. Yeah, we our rules are very... Yeah, I don't have... Now, other states may be different, but here in Ohio, you told me you're going to go commit an act of terrorism tomorrow. I don't have to say shit to nobody. I don't have to say nothing. Now, if I do it, I'm not in trouble. But if I don't do it, I'm also not in trouble. So I'm under no obligation to report it. So there are times where you have to do things, but most of the time you don't have to. Can a mime be a lawyer? Yes, probably. Pseudosnark says, I put an offer in to buy 8 acres of rural land. Oof, there you go. Good luck, man. Seller has 2 days to respond. Well, there you go. Good luck. Burblaw says, hi, Sean. Not a question or anything, but I wanted to say you are my go-to law tuber after Nick self-imploded. Well, thank you. I appreciate that. All right, guys, so let's get to the Karen Reed stuff. We addressed everything here, so let's get to the Karen Reed hearing today. Like I said, this was kind of like a last minute thing that happened. So nobody was I wasn't expecting this, but apparently some people seemed like they were. So let's get to it. Let's get to it. So here we are. So look, they don't even have the screen ready. They don't have the fan ready. The fan's not even going, chat. The fan's not even running. So here we are. So
Judge, this is 22-117 and 23-313, the Commonwealth versus Karen Reed, and separately the Commonwealth versus Aiden Kearney. Can I have the parties identify themselves?
Mr. Clerk, hold on just a moment, please.
Sure.
I need to plug in because I believe we have parties on Zoom.
Okay, I'm
And
sorry.
it's also my understanding that we're only here on case 0117.
That was also my understanding.
Okay.
Thank you.
And do you have the Zoom identification link for me, please?
I do. It's right here.
Thank you.
There's no passcode.
Thank you.
Karen Reed and Turtle Boy, guys. Karen Reed and Turtle Boy are all appearing by Zoom. Only the prosecution's in person today. So this is not at all uncommon.
Okay, Mr. Clerk, you may
Judge,
call the
thank
case
you.
and identify the parties.
22-117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Hank Brennan for the Commonwealth, relative to docket 00117.
Good morning, Attorney Brennan.
Good morning, Your Honor. I'm Robert Cosgrove. I'm a special prosecutor on the Aiden Kearney cases, and I suppose for purposes of this motion, I'm the respondent to the Rule 17 motion.
Good morning, Attorney Cosgrove.
Good morning.
Hello, Your Honor. Timothy Bradel for Aiden Kearney. I see him on the Zoom for the record.
Good morning, Attorney Brado. Good morning, Mr. Kearney.
And Mark Federer for Mr. Kearney. Good morning, Your Honor.
Good morning, Attorney Brado.
And good morning, Judge. Attorney David Yanetti for Karen Reed, who is also present on the Zoom.
Good morning, Attorney Yanetti. Good morning, Ms. Reed.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Attorney Little. Anyone else here that we need to recognize before we proceed? Doesn't seem so.
No, you-
Okay. Folks, we are here on two related.
This is where I wished there would have been like Mr. Dick and Balls, 1488, or Harry Wiener or Chad Zumach. Those would have been the funny things, kind of like the whole trial thing with was that Nick's hearing where everybody's like, no, Judge, I'm gonna tell you what's up with the April hearing. That would have been the best. Today you learn Cosgrove is a dick. Oh, he's been a big piece of shit lately. He's been a big piece of shit. Yes. Bama says, what is it with this attorney, name, the name attorney and then their last name? Because they're, I don't know, some places call you that. I mean, Bama, like if I wrote an email, I'd say, dear attorney so-and-so, that's not that weird. So they do. But yes, I was waiting for the that was April's hearing, yeah. But you know what I mean. It was a good times, yes. Yes. So I was waiting for that to happen. It'd have been the best. Somebody just screaming out in the middle of the hearings. But that didn't happen here today. So here we go.
Matters this morning. As an initial matter, we are here because there seems to be some confusion concerning my order of March 20th on docket 615 on the Commonwealth's Rule 17 motion. Also, we're here because there has been a motion for protective order, docket 636, filed by intervener Kearney, and so we will hear that as well. So with regard to my order, let me start by saying this. Going back to Attorney Brennan's affidavit filed in this case on March 5th, 2025, in support of the Commonwealth's motion for records, Attorney Brennan, you specifically stated that, quote, it's been represented to the court by defense counsel Bradel on behalf of Mr. Kearney that there's an implicit long-term mutual assistance and mutual defense agreement between counsel for Mr. Kearney and counsels for this defendant, Reed. On the basis of that sworn statement, I specifically inquired of you, Mr. Brennan, at the hearing on this matter last week, do any of the 3 categories of documents and data that the Commonwealth seeks by the Rule 17 motion include communications with Mr. Kearney and counsel for the defendant in this case? You replied, no, these would be privileged. So based on these representations and the court's belief that there were no privileged materials implicated by the Commonwealth's motion, I ordered that all communications between Mr. Kearney and Ms. Reed during the time frame in question with regard to these 3 articulated categories be produced. However, subsequently, the special prosecutor in Mr. Kearney's case, in possession of the documents in question on March 26, informed the court that 1, there are in fact a substantial number of communications within the documents and data requested that are indeed communications between Mr. Kearney and Ms. Reed's counsel. And moreover, the special assistant district attorney in that case took the position, contrary to the one asserted by Attorney Brennan in this case, claiming that those communications are not, in fact, privileged. So my order did not specifically exclude from production communications between Mr. Kearney and Ms. Reed's counsel because the court was told there were no such communications, and in any event, the Commonwealth acknowledged that they were privileged. So my first question is to you, Attorney Brennan. Respectfully, did I misunderstand you, or perhaps vice versa? In other words, I understood that you weren't requesting the production of any privileged communications, to wit, communications between Mr. Kearney and Ms. Reed's counsel. And as such, if that is the case, and we did understand each other, I can simply clarify my order for Special ADA Cosgrove that those claimed to be privileged communications will be excluded from the Rule 17 production, and we can move on. If that's not the case, I'd like to hear why.
Sure. Okay, so you notice the judge is saying here, is there just a misunderstanding? I seem to understand it. Apparently you didn't understand me. Maybe we didn't understand each other. This judge is actually being very diplomatic about it, saying, what the fuck are you doing? And are you sure there's nothing you want to say about this? So this is his way of saying that. That's his way of saying, do you not understand the words coming out of my mouth? Why are you and this other prosecutor not on the same page? I'm very miffed right now. So I'd like you to explain it.
May I?
Yes, you may.
I think there are 2 separate issues regarding privilege. One is whether Mr. Kearney's attorneys, Mr. Betterow and Mr. Brado, have privileged communications, and separately, Ms. Reed's attorneys' communications with Mr. Kearney. When Your Honor asked the question, I believe we were referring to Mr. Kearney's attorney. And so what I understood from the motion filings is that there were no privileged communications between Mr. Kearney and his attorney in those phones. And so there would be nothing privileged to protect.
Okay, I specifically asked, does this include communications between Mr. Kearney and counsel for the defendant, Reed?
I don't doubt that you asked that if that is what happened, but that wasn't my answer to the question because perhaps I was focused more on Mr. Kearney.
So you confirmed today that we misunderstood each other?
Or I misunderstood. I'll take responsibility for it. But I was trying to be protective of the attorney-client privilege between Mr. Kearney and his attorneys, Mr. Brado and Mr. Betterow.
Okay, well, we all agreed, counsel, that those in fact would be privileged communications without question.
Of course.
So let's turn to, if you would.
Now, I will say Hank did it the right way here when you fuck up, even if you didn't fuck up, just like, Your Honor, you know what? I assume the responsibility here. You know what, Your Honor, it's all on me. He does that because if you come up there and say, that's not true, it better be a matter that really fucking matters. Here, he hasn't had any problems yet. He's the golden boy still, so he can get away with this.
The second issue, which is one that you raised in your affidavit. You specifically raised that question in your affidavit, docket 547.
Undoubtedly. I do not believe there is any attorney-client privilege between Ms. Reed's lawyers and Mr. Kearney, because those communications are not covered by attorney-client privilege because none of Ms. Reed's lawyers are attorneys for Mr. Kearney. I pointed out that in an earlier hearing, and I have the transcript of it, it was December 17, 2024, when there was litigation in Mr. Kearney's case.
That doesn't mean there's no attorney-client confidentiality, because if there's some way they could show that Turtle Boy's acting as an agent of Karen Reed and the attorneys, then there is attorney-client confidentiality. That's the same reason why, for example, if an attorney has a secretary, that's all protected by attorney-client confidentiality. If there's a private investigator hired, that's protected because they're considered agents. So that alone doesn't necessarily give you the out, Hank, but I understand that he's running with what he's got, which is nothing.
Docket 0313, that there was a position taken by Attorney Bradel. And he began by telling Judge Krupp, well, there's a joint defense issue, Your Honor. And Judge Krupp asked, so it would predate any jeopardy to Mr. Kearney. And then Mr. Bradel responded, well, it's a little more complicated because we know he was under investigation along with Ms. Reed without any resultant charges, so we would contend that does not fall under the umbrella. After more questions by the court, Mr. Bradel answered, we don't have an agreement, but there's been an ongoing long-term implicit mutual assistance and mutual defense that I myself have been part of for a long time, and Attorney Betterow has as well. And Judge Krupp said, I really have no idea what that is. And so inevitably, there was no establishment of an attorney-client relationship between the two. Inevitably, and after that,
now,
Attorney
attorneys and defense teams can have a mutual defense agreement where they'll work together on this. Attorneys, like, so Karen Reed's, like, you hear about this every once in a while. If there was another case where there was a mutual defense agreement, mutual defense kind of pact. Yes, and this is the thing here. Hank is a very skilled defense attorney, so he's doing really good job at avoiding all the landmines right now. But yes, he got caught, and now he's talking his way out of it, and he's doing very good at it.
to file an appearance on behalf of Ms. Reed. And in that, there was a supplemental motion, and it's docket 549 on 0117.
And docket 549 contains Attorney Yanetti's sworn statement that there was no joint defense privilege between Ms. Reed and Mr. Kearney.
Exactly. And so I think I had the assumption there was no attorney-client privilege. If I misspoke, it confused the court. My apologies, but inevitably, there is no attorney-client privilege that I understand exists. And so I do not know what is in these phones. I have not asked. I don't want to know unless it's pursuant to a court order. But based on the affidavit of the search warrant and based on the pleadings in this case, and there's two very important pleadings, I may have mentioned them to the court on the last date. But those pleadings, which were filed publicly by the Commonwealth, and it's docket number 53 relative to Mr. Kearney's case 0043. In that pleading, it is set out by the Commonwealth's pleading that there is, in fact, information demonstrating that the Reed team provided Mr. Kearney with information, documents, videos. It suggested that at times they would suggest angles for him to use it or to refrain from using it. And it provides a number of examples, including an example on 8823 when
you're making a very good argument that Turtle Boy is an agent of the team. He's doing work on their behalf. Could almost argue he is an agent of the team.
they're asking for information, Mr. Kearney, so one of the attorneys.
Attorney Brennan, I'm going to ask you to pause right there because I think we've reached a point where I have a threshold issue that may require either a Bishop Franklin protocol or some inquiry into the nature of the privilege that may or may not be asserted by Attorney Bradel. And so I think it's appropriate at this time, Attorney Bradel, that I turn to you, not with regard to the protective order, but with regard to the issue of whether your client claims a joint defense agreement and related privilege to communications between himself and attorneys for Ms. Reed, such that I need to limit the scope of my order of March 20th.
Judge, thank you. We do not assert such a privilege. I said in a much different context a long time ago that we had been sharing information and talking to each other and helping each other. And I said that there was an issue. I didn't say there was a privilege.
Okay.
So we are not asserting that. There is no formal agreement. There's no formal privilege. I said it was an issue to be looked at the time. That's all I said, Your Honor. And in terms of this, Your Honor's order, I don't even know why we're talking about this, Your Honor. The ostensible purpose of the Commonwealth's request was to attempt to show consciousness of guilt on the part of Ms. Reed. So why would communications to other parties besides Ms. Reed have any relevance? And in fact, in your order, you just say that the only communications that are on the table here, so to speak, are communications between Mr. Kearney and Ms. Reed.
I'll stop you right there, Attorney Bradel, because you raised an excellent point, and that point being is that point from the court's perspective is in an age of group texts and other means of communications with multiple recipients at the same time, we certainly have the likelihood of communications between your client and Ms. Reed that may also include members of her defense team. So it is my belief that is what might be at issue, but I will probe further of ADA Cosgrove on that point.
I mean, if you ask me, Your Honor, the pleading, that the impounded pleading filed by Mr. Cosgrove is completely immaterial. The whole reason for this is consciousness of guilt. So there are we're privy to these extractions. There's absolutely nothing in them that is covered by Your Honor's order. There's no communications between Mr. Kearney and Ms. Reed regarding witness intimidation. There are none. So there should be exactly zero documents or texts or emails that should be responsive here. Absolutely zero. And I don't have the thumb drive that Mr. Cosgrove gave to the court ex parte. So I can only imagine what's in that. And we are anticipating a request that you will look at that, to ask you to look at that in camera and see if that complies with your order. It doesn't. It cannot comply with the order. Your order said Kearney and Reed, not third parties that may or may not have spoken to Reed. And these are things that are privileged among that team. So this is a can of worms that the court did not open by any stretch. And I think that, Mr. Cosgrove's role here is completely ministerial, Your Honor. And the fact that he's trying to jump outside of your order is incredibly inappropriate, in particular because these two prosecutors are in different positions due to a conflict of interest, an expressed conflict of interest that has been identified and supposedly acted on by District Attorney Michael Morrissey. So their communications need to be limited because there is a conflict. Your Honor limited those communications very appropriately to potential evidence that those two defendants could have communicated and in terms of some criminal acts. And we're telling you there's nothing there. We don't expect you to rely on our interpretation, but there is nothing there relative to your order.
Thank
So
you.
the fact that the-
Attorney Breda, I'm gonna ask you to pause for a moment, and I'm gonna hear from Special Assistant District Attorney Cosgrove, specifically with regard to this issue.
Listen to this worm.
In your communication to the court, you suggested that in your judgment, the production would sweep in a substantial number of communications between Mr. Kearney and Ms. Reed's attorneys. How would those be swept in when the order specifically calls for communications between Mr. Kearney and Ms. Reed?
I think the actions of Ms. Reed's attorneys on her behalf are the actions of Ms. Reed. And if one reads the sweep of the communications between Mr. Yanetti and Mr. Kearney, and between Mr. Jackson and Mr. Kearney, and Ms. Reed and Mr. Kearney, one sees a
I love him
pattern
so far.
of feeding information
I think he's amazing.
to Mr. Kearney. I think that they act together in that respect, Your Honor.
Thank you, Attorney Cosgrove. Notwithstanding that position, the court's position is that the order spoke very specifically and very clearly to limit the Rule 17 motion to the production of only communications between Defendant Reed and Kearney and Defendant Kearney concerning those three areas of inquiry. So I am specifically requesting and ordering the Commonwealth in that case to review the documents called as a result of the Rule 17 motion in my subsequent order, such that the production will only include communications between Kearney and Reed.
Well, I will, of course, comply with Your Honor's order.
Thank you.
But
Folks, I think we've covered that point, and I don't think I need to hear any further on this. The order is clear on its face, and I expect the parties to comply with it. I'd like to turn now to the issue of the motion
Wow.
for protective order from Mr. Brado. So I'll hear you on this, appreciating.
This judge isn't put up with shit. Unlike Judge Cannoni, he controls the courtroom. Prosecutor, you're fucking up. I told you what you can reveal and what you can't reveal. The communications between Yanetti and Turtle Boy and Alan Jackson and Turtle Boy have no bearing on Karen Reed's consciousness of guilt. You can't turn those over. You can only turn over the Karen Reed stuff. Karen Reed and Turtle Boy. Notice they seem to act like they're like, well, we just didn't know what you meant. What a completely retarded argument. So, no, Thunder Dragon, they want to use this. They want to use this stuff to show Karen Reed's guilty by saying Alan Jackson and Yanetti are acting on behalf of Karen Reed. Therefore, anything they do is Karen Reed's action. So that's what they're talking about here. But that was impressive. He's like, fuck you. We're not doing this anymore. You know better. We're moving on.
That I have had the opportunity to review the attachments and certainly the basis for this, but I'm not, I'll preview where I end up, Attorney Brado. I'm not quite clear
Sure.
on the scope of your request as contained in your draft order. As an initial matter, I'm only issuing an order in the Reed case. This is not a hearing on the Kearney case. I appreciate that you have a congruent request to the court in the Kearney case, and that it may make sense that whatever the court does in that case should follow what the court does in this case. That would seem to make sense. But I'm only hearing the motion as it regards to this case. Your request, I'll note, asks that the court order all prosecutors and police in the above captioned case to maintain the confidentiality of the cell phone data and any other investigative information and or discovery in each case. So I'm not prepared to discuss the entirety of investigative information and all discovery in this case. I am tasked with only addressing Mr. Kearney's specific cell phone data that is the subject of my order of March 20th. But you've specifically requested that the court order that police and prosecutors are ordered to refrain from sharing such information with particular parties identified in Mr. Kearney's affidavit and any other parties not part of the retained prosecution teams of Ms. Reed or Mr. Kearney. Aren't they already under a duty not to share such information with anyone outside the bounds of what you request?
They are, Your Honor. Judge Kearney specifically found a substantial risk existed that any further communications about the evidence or the witnesses would jeopardize a fair trial. And she made that specific finding, and she imposed, I believe it's a 4-part gag order on the Reed attorneys. Nonetheless, as shown in my exhibits, Judge, these outside people are receiving information that in no way would the prosecution team ever share outside of anything ethically share anyway, any such information. And there's 3 examples of people who are, out there saying we've gotten this, we've gotten that. And we strongly believe that they are doing so. Just to avoid the slight awkwardness, Judge, of me arguing something that benefits Ms. Reed, I would invite, just for the record, the Reed counsel to join me in this motion, Judge, because of the leaks that are going on, just as a threshold matter, if I may do so, Your Honor.
Are you merely asking me to add a belt to Judge Kearney's suspenders?
I think so, Judge, because we need one, and we need one as to the specific information. These 3 people have repeatedly stated that they're privy to inside information, and with respect to Mr. Kearney's information, but although we strongly contend there's nothing in there that is responsive to Your Honor's order, nothing. To the extent that there's anything that's shared between these 2 different prosecutors that are on separate islands due to a stated conflict of interest, we want to specifically ensure that as to the discovery that Your Honor's focused on here, that these orders are in place, that there's a specific order. It's sort of another step from Judge Kearney. She said that, well, the general rules of ethics aren't working here, so I'm making a specific finding. I'm giving you a gag order. Well, guess what? Judge Kearney's order didn't work either, based on my exhibits A, B, C. And so we're asking for another step to just really put a fine point on it, that these 3 people must stay away. And a general order as well as part 2 is my part 2. And to the extent that those people have any sort of further expressions of leaks in the media or on the internet, I think that ought to be grounds for a live hearing with sworn testimony about these leaks.
Understood. Okay.
So that's why I'm asking, Judge. Thank you.
Thank you, Attorney Brado. Attorney Yanetti, do you have anything to add on this point?
We don't. I mean, I think that we generally take no position here. It is concerning to me that Special Assistant District Attorney Cosgrove revealed in a publicly filed motion communications with, or I should say between Mr. Kearney and counsel for the Reed team when the court's order was specific. My understanding is that he omitted some statements of caution and admonitions that we may have given to Mr. Kearney about the nature of demonstrations, etc. So it seems as though he cherry-picked statements in an effort to make us look bad when it was outside the court's order. It was unnecessary.
Attorney Yanetti, are you speaking to something that Attorney Cosgrove has purportedly done in this proceeding in the 117 matter?
No, I believe it's a motion that he filed in his prosecution
Okay.
again, detail, that material.
Thank you. Okay. Okay, folks, I will take that matter, the motion for protective order, under advisement, and will endeavor to respond to you as soon as practicable on my decision on that. In the interim, 88 Cosgrove, Special 88 Cosgrove, I'd ask you, how soon do you believe the Commonwealth can reproduce the records in question per my order that are called for by the Rule 17 motion?
Well, I would say we can probably extract from the thumb drive the conversations with Mr. Yanetti and Mr. Jackson. I may be able to get it done today. I think Monday would probably be a realistic filing date.
Thank you. We'll expect something by close of business Monday, and if you encounter any difficulty or challenges in doing that, just please let the court know, and we'll make whatever accommodations we need to make. Okay, folks.
Your Honor, is that thumb drive going to get returned to the Commonwealth?
Yes, it will.
All right, thank you.
And it has not been viewed, it has not been released, and it is being held under seal and impounded at the moment, and it will be returned to the Commonwealth promptly.
Thank you very much, Your Honor.
Attorney Brennan.
Your Honor, just for clarity of the record, I'll be brief. There has been no conversations between Special Prosecutor Cosgrove and I about contents of any of these items. In fact, even though I do not think I had to, that's why I filed the Rule 17, so there is a clear public record that we're beyond reproach. Secondly, the pleadings I referred to were pleadings that were filed in Mr. Kearney's case publicly before this issue even came up. So it is not divulging information to disseminate to the public. And finally, just so it's crystal clear, I filed a motion for a gag order in Ms. Reed's case because there was significant evidence of distributing protected materials, and that order was allowed at my request. There is no witness or person, as far as I know, in the Reed case that has disseminated any information improperly. I would not allow it or tolerate it if it happened. So I want that to be crystal clear based on the representations we just heard.
Understood. Thank you, Attorney Brennan. Thank you, Attorney Cosgrove.
I mean, considering your police fucking released information, yeah, everybody's got a right to say what the fuck.
Thank you, counsel. No, we are adjourning the hearing now. Thank you, counsel.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you. Goodbye.
So there we go. They got caught fucking around, chat. It's like, why are you guys retarded? So it's interesting. It's interesting to cover and worth looking into here. Yeah, I'm not wearing suspenders. Well, yeah, it's not a game day. It's not game day today. Maddie's saying, Sean doesn't strike me quite like this order. I think he'd be sounding nicer sounding while being much more sarcastic and belittling. I wouldn't though. I would very much feel like this judge said, like, are you, can you explain what's the confusion here? I think that's the proper way to do it instead of just being like, rah, 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 rah. That's not how you should do it. That's not how a judge should act. Yes, he certainly tolerated discovery violations. Yes. I haven't been following the retrial. Is Judge Cannoni gone? No, this is one of those situations where there's the Turtle Boy and Karen Reed crossover. She's still in the case. She's still on the case. So here we go. We got some questions here and some stuff to talk about. John Coleman for member for 12 months. Thanks, John. He says, I got blue crabs from a blue waffle. Oh, no. It burned. Well, ooh. Oh, shit. And Rumble didn't start. Sorry, guys. Sorry. Rumble's going to be late. We'll have to catch up. Sorry, Rumble. You're just now learning stuff. I got blue crabs from blue waffle. It burned. That's not good. That's not good. HIV1 says, do you need a law degree to run as a district attorney? I think it would depend upon your state. But in Ohio, for example, that is an actual qualification. We have a qualification for that. It's in the Ohio Revised Code. It's under state law. And there is the qualifications for candidate for prosecuting attorney. And this was effective in 1992. So I'm sure it goes back even further. But obviously it says no person shall be eligible as a candidate for the office of prosecuting attorney, which is what we have here in Ohio. We don't have district attorneys. We don't have Commonwealth attorneys or state attorneys. Each county in Ohio, all 88 counties. Yes, chat. We have the base number. There are 88 counties in Ohio. So there are 88 prosecutors. And then an untold number of assistant prosecutors. Nobody shall be eligible to be a candidate or be elected to such office who is not an attorney at law licensed to practice in the state. So you have to have a law license in Ohio at least. No prosecuting attorney shall be a member of the General Assembly. That is Ohio's Congress. So that means the Ohio House or the Ohio Senate. So you can't be a member of our General Assembly, the legislative body of the state, or a mayor of a municipal corporation. So you can't be a mayor of an incorporated town. If you happen to be like the leader of a unincorporated village, you could probably get away with it, but still that'd be a little awkward. So yes, in Ohio, you have to have a law degree, and you also have to be licensed. So not only do you have to have the law degree, you have to be licensed. So let's say you're disbarred, or you just never practiced, or your license lapsed, and you're like, yeah, I went off and did something else for a while. Doesn't matter. You have to be a valid licensed attorney. So that's important. Chugi Show is saying Sean is never late. He just lives in the nothing ever happens o'clock time zone. Somewhere, something in happening at some time, but not here. Sad. Well, sorry. And Kevin Doris says they pulled Elise Stefanik because the New York GOP was going to pick an ever-Trumper and General Shithead to run in the special election and thought they might lose. Well, that makes sense. And Kathy, you're a realtor in New Jersey, guys. Remember, in New Jersey, not the Channel Islands, because she'd be tweeting in pounds, super chatting in pounds. But guys, if you need a realtor in Jersey, get a hold of Kathy. I'm sure she'll take care of you well. She says, and by the way, for the $10, thank you, Kathy. Hope you're doing well tonight. Says the RNC is losing special elections. Where is the infrastructure? Yeah, that's been an issue right now. Elise is going back because of incompetence. Yeah, and if she's going back to shore things up, yeah, I guess she will be. So we'll see. So let's see. Where are we up to now? You should be an attorney to be the district attorney. I think so, but yeah. Yes, 14 courthouses. Yes, Karam is right. 14 boroughs and 88 counties. We don't have boroughs in Ohio. We don't have boroughs. We don't do any of that shit. We just have counties. County is the statewide, counties are the thing. We don't have boroughs, but yes, 14 courthouses and 88 counties. Oh. Yes, there were actually 89 counties in Ohio until 1939. Yes. Ohio did have 89 counties. We had a different map. But yes, we have 88 counties right now. So there are counties that can set up charter governments. So there's 2 counties, like Cuyahoga County has a charter government where people run as county, the county boards that have commissioners, and it's a different setup. But otherwise, you just basically have county commissioners and everything else. So that's how it works. That's how it works. Yes. So funny. So funny, chat. I think it's a very good joke, Pseudo Snark. Yes, you made all that last stuff, but I thought you were making like a World War II joke. So that's what I was going along with. But I guess. You forgot those pesky to do CLEs, yeah. Access like Pisco. No, Pisco's practicing. Pisco graduated law school and from what I understand, passed the bar and is practicing. I have no information otherwise. I'm assuming he is. Is Clyde making me sneeze? No. Weather changes do that all the time. My nose is very sensitive for allergens and weather. So, Mother of Beagle says, not North Carolina. 88 counties is the same as the number of keys on a piano. Yes, that's how they teach it to kids here in Ohio. We have 88 counties, and there are 88 keys on a piano. County is better than borough because you can misspell it cunty, and it passes spell check. Yes. CM Book says Jersey is a Channel Island. I wasn't joking. It was one of the territories of Britain that got occupied by the Germans. Guernsey and Jersey, the Channel Islands, they were occupied by the Germans during World War II. I wasn't joking when I said it's an actual thing there. Oh, today's debate would question. Okay, well, I haven't seen it yet, so I'm not sure. Sleuthie Goosey, how you doing? You just got here in time. We are going to go over the filing regarding the. Hold on here. Where is it? Hold on. Okay, so I've got it here, guys. This is a weird setup that we're using. We are gonna. Can I zoom in on this? Okay. So this is an interesting thing because this affects what's going on with Karen Reed, but it's in Turtle Boy's case. And guys, if you don't remember Turtle Boy, he does Turtle Boy Live. He's on all the time. He basically broke Karen Reed's story and kind of brought it out to the world, highlighted all the sketchy shit going on. I mean, really, if it wasn't, Karen Reed would have no publicity. Turtle Boy has kind of, I disagree with how he did some things, but hey, he did them. He's the guy out there putting foot to ass. So I've kind of realized, you know what, I'm going to step away from that. Turtle Boy has been charged by the authorities in Norfolk County with witness intimidation, multiple counts of witness intimidation to people like the Alberts and the McCabe's and all these shitheels that testified in the Karen Reed trial. So that's why Turtle Boy has a criminal case right now. But yes, guys, Sleuthie Goosey, if you guys see her out here on YouTube, give her a follow, take a look at her. Also on Twitter, she's got, always dropping the information that's out there. Really good supply of documents and information and just good commentary, taking care of things. So give her a like, give her a subscribe, take a look at her if you get the chance. I would recommend it. You say, oh, I'm sitting here messing with the new spreadsheet. Perfect. All right. Yes, great researcher. Very good researcher. All right, guys. So I need to remove the long crime thingy now, the overlay. But gone. All right. So it's Commonwealth of Massachusetts versus Aiden Timothy Kearney. I said it right finally, chat. Okay, so it's the Commonwealth's opposition to defendant's proposal to compel screening of seized devices for purported reporter privilege materials. Now, remember, chat, there are times where you will have taint teams and other parties that examine. Are we getting rain? No, it's just windy out. You can get a third party, like a special master or a taint team, to go through, like, for attorney-client information or for reporters. Reporters have privileges. They have sources. So he does have the right to say, look, you can't just rifle through all my shit. And he's trying to do this. Well, the Commonwealth is opposing him. And it sucks, guys, because I can't keep stuff highlighted as I go. And it's a little frustrating here. And I don't know. And real quick, I want to check something here. Is this going to let me save it? I don't know if it'll let me save it. Because this is on some weird fucking app where it's like a flip device. It's like a flip thing. It's like what you do is like you do it like this. And it does that, which is kind of weird. I don't particularly care for it, but that's the way it's been posted. So anyways, this is from Turtle. This is the Commonwealth's opposition. So they say on October 11th, they seized, pursuant to search warrants, multiple devices from Turtle Boy's home. 2 were preliminarily searched under authorization in the warrant. Thereafter, the defendant, through counsel, asserted that there were materials on the devices subject to attorney-client privilege. The Commonwealth therefore agreed it wouldn't search without first implementing a taint team. Guys, they did the taint team thing with the Mar-a-Lago documents because there were all kinds of privileged materials. So a separate party, and the way a taint team would work is another part of the Commonwealth's office would look through everything. They would never talk to the special prosecutors, and they would say, look, here's all the shit you can have, and they would get rid of the rest. So they say discussions followed as to the appropriate members of the taint team. And they say in Special District Attorney Ken Mello identified as an expert, Stephen Verano, to extract the information from the devices, and retired District Court Judge Joseph Macy to screen out protected attorney-client communications, and confirmed with them their willingness to serve in that capacity. So that's good. They have a special district attorney doing this. They identify an expert. They were going to use an expert to do the devices, and then a retired judge. So it's a third party, guys, working here. He's going to go ahead and screen out the attorney-client communications, because who better than an attorney, but also an attorney that's a judge? They pick somebody, and that's part of this. You work out your problems. And I say, I don't know where Hella is with the invocation of a taint team. She's not here yet. But they say, for reasons previously litigated but not germane to the present discussion, the Commonwealth made no progress in advancing the search of the devices until August 12th, 2024. When it filed this court a motion for examination of the digital, now we gotta hold on here, chat. I think I got back up time. So, of the devices, they say the Commonwealth anticipated this motion. The Commonwealth anticipated its motion would be heard on the next court date, but the 5 court appearances following considered intervening matters before the court reached a taint team question. And they talk about on December 27th of this past year, this court issued an order establishing a taint team procedure. In pertinent part, it provided defense counsel will file with the court a list of search teams to facilitate, or search terms, to facilitate the identification of attorney-client privilege information. The court specified certain terms that allowed for additional search terms if necessary. And they say, however, if the defendant offers additional search terms, he shall file an affidavit with the court affirming that they are necessary to identify and locate protected information, or otherwise explain why those terms are necessary. The court also provided that if the defendant believes supplying certain information required would compromise confidentiality, he may submit the terms of the court under a protective order without disclosing them to the Commonwealth, including therewith a statement of good cause for such terms. So the way this is going here, Turtle Boy, if there is anything, and if we have to tell you about it, we'll breach confidentiality, you could provide it independently to the court. So you do get an ex parte hearing here, and the court would take a look at it and determine it. Now, here's the thing. You're like, well, can you abuse that? Certainly. That's why you don't abuse these things. The court will nuke your boots off. So this is why they have to be very careful about what they do, but they have ways of getting through this. Oh, that's not right. So they say argument. And they say neither the Supreme Court nor the Supreme Judicial Court, meaning the Massachusetts Supreme Court, has adopted a constitutional reporter's privilege. And they say, as a rule, the reporter's privilege arises in context of reporters subpoenaed or summoned to testify. And they talk about federal cases, Brandsburg v. Hayes from 1972. And they say therein, there was a New York Times reporter and a Massachusetts television reporter were subpoenaed before grand juries and ordered to name sources that had provided them with information for their articles. They refused and were held in contempt. And at that point, Justice Byron White, and that's just, yes, there was a Justice White, declined to find in the press clause of the First Amendment a testimonial privilege for newsmen that other citizens do not enjoy. And guys, you hear about this every once in a while. For example, there's the famous case of Judith Miller involved in the Valerie Plame scandal. She refused to name her source, Scooter Libby. And she spent many days, months and months and months in federal jail. Jailed every day because she refused to name her source every day. The court would bring her in and say, will you tell us who it is? She said, nope. And he said, you're still in contempt and you go back to jail. They did say, however, White noted favorably a previously established test requiring the government to show a substantial relationship between the information sought and the subject of overriding a compelling state interest. So they talk about why is this important? They talk about this is a big deal. There are still limits to what the courts can do, and the government still has to show a reason why they want to get this information. So they talk about they go on here a little bit further, guys. We're just going to kind of breeze through this. They say other federal cases have attempted to apply Brandsburg, but have kind of bounced all over the place. And they say Massachusetts likewise has not adopted the Reporter's Shield law. And they say bills establishing it have been proposed in the legislature, and they have uniformly died without passage. And they say with respect to search warrants, there is no search and seizure without a warrant shall be conducted, and no search warrant shall issue for any documentary evidence in the possession of a lawyer, psychotherapist, or a clergyman who is known or may known to have a relationship with any other person, which relationship is the subject of a testimonial privilege. Now, that's how this works. If you know the lawyer may have information, you can't go seize it. Or if a psychotherapist has it, or a clergyman. Remember, guys, your priest penitent privilege is a very big one too, but you also have psychotherapist privilege because unlike every other kind of doctor, this is where you'll talk about feelings and thoughts. And they say absent from the list is journalist or reporter. So they also say before ordering to divulge a source, the judge must consider the effect of compelled disclosure on values underlying the First Amendment in Article 16 of the Massachusetts Constitution. So they keep going here, and they say using that analysis, the defendant's position is worse than that of Pappas, the reporter in Brandsburg. And they say, first, he's not being compelled to divulge anything. Rather, information discovered will flow without his compelled cooperation, meaning we're not forcing him to do anything. We're just going to hoover up the data on his phone. He's being compelled to provide his phone, acquired by a lawful search warrant. They say, second, he's not a disinterested reporter. Rather, he's the defendant in a criminal case seeking to conceal information that may well be damaging to him. Notice, they're saying he's a defendant in a criminal case. Okay, he's a defendant in a criminal case. And he's concealing information that may well be damaging to him. Not that it's certainly going to be damaging to him. Notice, they're saying, well, obviously he's trying to cover his ass because this may hurt him. Not that we know it's going to hurt him. So listen to the weasel words there. Listen to the weasel words. So they say there's the Supreme Court had a little difficulty saying that a legitimate grand jury is a compelling interest that requires a reporter like any other citizen to appear and testify as to his sources. And they say the court has no difficulty concluding that there's the defendant's subject to multiple indictments that far outweighs any abstract public interest in protecting the free flow of information. You know, God, they're so if this is really the key to sinking Karen Reed and Turtle Boy, then the past years have been pathetic on that part by the state. It's interesting what they do here. In fact, the judicial finding of probable cause for the search warrant by a justice of this court should be dispositive. And they say further, the affidavit in support of the warrant alleges that there's probable cause to believe the data will contain evidence of conspiracy. Okay, and I have a feeling it's not going to show that. They say indeed, if it does, there's no anonymity when you're actually involved in a conspiracy. And notice the Commonwealth in their thing says, we're not disputing that he's a reporter. We agree, but there's just no reporter privilege. That's not how this works. And the freedom of the press doesn't apply here because you're allowed to say whatever you want, but you may be held accountable for it. So what do they talk about here? Well, they talk about the taint team, and that protects his Sixth Amendment rights here. And hold on, chat. We are... Oh, wow. That looks good. Heck yeah. And then okay, geez, that's brutal. That's rough. So they talk about how this works with attorney-client privilege and protecting other privilege. They say it's been long-standing to practice to afford this as such physical documents. So, and notice they're going to say, look, yes, taint teams protect physical documents. And they say the taint team represents one example of special care of afforded attorney-client privilege. And they say, well, special care procedures are routinely employed. There's a reasonable possibility that attorney-client materials may be unearthed during a physical search. No such procedures are routinely employed as to other confidential and privileged information. They say, rather, if such material comes to light, the remedy, if any, is simply a motion to suppress the information or a motion in limine as appropriate. The same should be true of electronic searches. Yes, that's their argument is if we illegally come across evidence, well, you just tell us we can't use it. Well, there should be punishment. You guys should be on top of this. If you want to file a search warrant to get through someone's shit, that's on you, and you should be held responsible for it if you abuse it. LPR, Libertarian Podcast for you guys. Tyler Yonke, the best podcast review for libertarians, or the best podcast, best review of Libertarian Podcast. Still not sure which one it is. I think it goes both ways. Tyler's out there getting the libertarian thing done. With that said, though, Tyler does great stuff out there in the great state of California. But yes, you got around the priest penitent privilege. Yes, guys, and depending on your state, this may be a privilege. It may not be one. There are states that have all kinds of privileges. There are states that have very few. It really all depends where you live. So if you're not sure, you can check it. Your rules of evidence will list out the privileges that exist. And for example, here in Ohio, you can look up your state's rules of evidence. They should be available online. And you can go to you could talk about privileges. You could talk about all kinds of things that are there. And you can work your way through them as you go. So there are some privileges, but you're not guaranteed to have them. Let me see if I can find our list of. Let me see if I could find it. Let's see here. So obviously we have attorney-client privilege. We have other privileges that may exist. There's doctor-patient, you can have a privilege, but it's got to be for the purposes of, medical treatment. That stuff will be protected. It depends on the privileges in your state. So check your state's laws. Check your state's laws. Tyler goes both ways. Yes. Not the doctor's banging the patient. Well, maybe if that's part of your treatment, it might be. It might be if it's part of it. So, all right. So, anyway, guys, they move on and they say that, first of all, Massachusetts still doesn't recognize the reporter's privilege, and that should end the discussion. They say, though, and they point out, second, though, anytime that a court is given this confidentiality to a reporter, that they protected it, it's been under a test where the test must yield to the government's compelling interest to execute a valid warrant. So the government's compelling interest, we're down to a rational basis test, chat. This is not strict scrutiny. We're not, that's that's the problem here. Somebody just messaged me something. So, they're like, this interest here is not going to be good. It's not going to be horrible. The compelling interest, it's more than rational basis, but we're not to strict scrutiny. I think I said that wrong just now, chat, but I want to make sure it's clear. It's above rational basis and it's a compelling interest. So yes, it's a pretty important thing, but it's not to strict scrutiny. You're getting the idea where it's narrowly tailored, but it's got to be a special important thing here. So they say it's pointless to screen out purported information because they're going to examine it all as they go through it. And they say there's a variety of situations where there's a confidential relationship that merits protection, even if it falls short of a privilege. And they say to expand the taint team search to anything like that, would be capable of being pierced under appropriate situations. Unlike attorney-client privilege. Attorney-client privilege chat still, notice this, they say unlike attorney-client privilege, they're all capable of being pierced. And they would turn the search warrant and enmesh the special master in time-wasting and ultimately unproductive activity. Well, I don't care. Too fucking bad. Oh, no, it's going to take time. Sad. Oh, no, who cares? Wah, wah, wah. I don't care. Notice they didn't indent here. They should be deducted for that. So they say the taint team only seeking attorney-client materials is proper. They say that there's no there's no reporter privilege, and the court should deny it. Now, what is the most important part of this motion, you guys? Because we're almost done. We only got 2 pages left. They say the court should check to see whether the defendant had submitted search terms that would matter, and if he has, the court should check to see how this works with the court's order. They say if he's submitted terms but hasn't filed the appropriate affidavit, the court should strike the terms. And they say that they want to renew its argument previously brought that under no circumstances should the search terms be designed to, and this is the motion that we were dealing with today, guys, should be not designed to screen out conversations with Karen Reed's attorneys, including Alan Jackson and David Yanetti. Now, they point out that there's objections to this, but also that Karen Reed's attorneys have not and do not represent Kearney or Turtle Boy, but suggesting there is a joint defense. Now, notice we had to come into that hearing today, and what did Turtle Boy's attorney say? There is no joint defense, Judge. These guys are fucking high. Now, remember, though, if you work for Karen Reed's team, you still have attorney-client privilege. So just because they're not representing Turtle Boy doesn't mean that there isn't other ways you could establish privilege if he's their agent. Remember, chat, like if your attorney hires a secretary and he talks to the secretary, they can't go in and say, breach of privilege. All that information is now discoverable. No, that's not how that works. So they point out, though, that all the devices were seized before Turtle Boy was charged, before he knew he'd be charged, so nothing within them would be covered by the alleged joint defense. I mean, allegedly, but how the fuck do you know? How do you know? How do you know what's out there? Maybe he thought he was going to get arrested the whole time. You don't actually know that. You don't actually know that. You don't actually know any of that. You don't know that. Oh, what's going on? Nick's on with Dick? Oh, well, hope he's doing okay. They say since raising it, the terms to screen out things here, they say that, Turtle Boy's phone contains text messages, not only between Karen Reed, but also with Karen Reed's attorneys, Yanetti and Jackson. And the text messages make it clear that the Reed team was in telephonic and email communication with the same people. The Reed team reportedly provide Turtle Boy with information, including videos and copies of documents, sometimes with a request that he not use it yet, lest the prosecutors figure out where it came from. And they talk about these times where Karen Reed texted Turtle Boy, do you have the memo the town employees were emailed about speaking to you? And Alan wants to blast it. Like, yes, this is a problem. Karen Reed should not have been talking to Turtle Boy. Now, here's the thing, chat. when you're going to do sketchy, weird shit, this is where you use, like, you kind of open up the playbook. Like you find that you go to the library and you go Taliban playbook, or just a general intelligence operations playbook. How do you do covert activity and covert communications? You start out with cutouts. You have third parties you communicate through, and those third parties may communicate. And then they can exchange information and pass it along. You know, you have a burner to talk to your cutout. Your cutouts have burners. There are ways you could, like, get Obama phones. Those shit's cheap, man. It's like The Wire. Use the phone for a little bit, throw it out, get a new one. There are multiple ways you can do this stuff that will protect you. Now, am I encouraging you to engage in clandestine behavior and surreptitious behavior to avoid law enforcement? I necessarily can't tell you to do that. But there are ways they could have done this where the government would have found out what the fuck they're talking about. Signal? I wouldn't even have used Signal. No. Theoretically, you might have Signal on your phone and they could find a text message where you talk about the password and then boop, 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 done, boom, you're in. No. At the very least, you use other phones. You use other communications. Even better, I mean, it's impossible to do nowadays. Always voice. If you guys ever watch Goodfellas, there's a reason why Paulie never uses the fucking phones, because the phones can be tapped. And instead here, these guys are running a goddamn gossip column.
Nigga, is you taking notes on a criminal fucking conspiracy? What the fuck is you thinking, man?
Pretty much what happened here. They talk all about it. So there are ways you can avoid this stuff, okay? There are ways you can avoid it. You have to be thoughtful, though. And for Karen Reed and her team to talk to Turtle Boy and never think that they were going to be surveilled or these messages would never be sought after, given how loud Turtle Boy is, I think was very foolish. I think it was, yeah. If you're proactively and always act surreptitiously, then it's not wrong. Well, yeah. So, Winter Soldier says, do dead drops. Well, don't do dead drops. That's because dead drops could be intercepted. But tradecraft, like you operate through third parties. You got to be smart, guys. You got to be smart. Got to be smart. You can't be tards. You can't be retards. Because the government will look for a way just to take their hand and just right up your asshole. And then they just start going like this. Woo! And haul you out. You don't want that. You don't want that. Oh. So, they say Karen Reed's team responded to a request for information. And we talked about this last night for a minute, but we're going to get to the actual things here. They say, for example, in May, Yanetti texted Turtle Boy, dude, don't be offended if we don't shake your hand on the way into court. We want to maintain the separation in your independent investigation. I love how they do sick here because they're saying there's spelling errors. And it's like these guys are misspelling shit all over the place. They say the Commonwealth wishes to delay the taintee procedure no more than necessary. And they say here are examples of Yanetti and Jackson talking here. And this is, Yanetti actually texted Turtle Boy and is like, Attorney Yanetti. And it's like, he texted Turtle Boy and says, that was priceless, dude. Great fucking show. Really enjoying the turtle reporting, which tells me he's probably actually not listening. And then another day, Yanetti told Turtle Boy, you are a class act, Karen and her parents. Thank you. A few weeks later, he also texted, another great article by Turtle Boy. You're doing God's work. And then they were told by Turtle Boy on, that he will hold a protest on the courthouse steps where we will have a megaphone this time and make sure hundreds of people are there. And then Yanetti said, I love it. 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 Like Trump. And they say in response to his request for names of defense attorneys who might want to appear on a YouTube discussion panel, Yanetti forwarded the names of 4 lawyers and their cell numbers and suggested how to approach them. Still, so the fuck what? So the fuck what? And that's what the judge said today. So the fuck what? So the fuck what? So what? So what? So what? So what? And that's why the judge said you're not getting the Yanetti and Alan Jackson communications. That's not relevant. What Karen Reed said is relevant, and that's it. So they say that they want more time here. They want more time to get this done. They want a scheduled hearing on April 30th for oral arguments. And they suggest the court fruitfully forego the oral arguments and decide this matter on papers. They're saying we're wasting time here. And they say, although we understand that the forensic examiner needs to do a separate search for each term, but each search is not particularly time sensitive. I know you're going Control F. And you're going through it. So this was submitted by Robert Cosgrove, Special Assistant District Attorney. And yeah, so there it is, chat. But that was the thing that got shot down today. So that's interesting because it ended up getting shot down and we were going to talk about it. So, good God, this was stupid defense. They're going to look horrible in a trial. Remember, Edward, that stuff's not coming in because it's not relevant. Remember, their argument was, oh, look, Alan Jackson and David Yanetti, whatever they say, those are Karen Reed statements that are adopted. No. And the judge said, no. You can't do that today. Edward Scott says ham radios are markedly secure. No, it's not. Ham radio is broadcast in the open. The reason why ham radio and other things work, part of the reason why, think about it this way, chat, encryption or any of your means of communication using third parties, it's all about staying unobserved as long as possible. Because you should always assume you're going to get detected, you're going to get made. And if you're running encryption, they're going to break your encryption. So you should always look at this as it's like a bank vault. Bank vaults are never 100% unopenable. Bank vaults and safes are rated on the premise it's going to take a robber X amount of time to get into it with X amount of tools. Or how long does it take fire to damage the contents inside and burn through the safe? Those are things. It's all about time rating. It's not about how, can it effectively stop everybody? Because even a defensive thing, like the walls of Troy, they would only be rated, they could withstand for so long, but eventually they would crumble. Now, the Greeks got lazy and they just went in and stuck in with the Trojan horse. But the idea is even defensive fortifications only last for so long. The reason why you have them is hopefully you can cost too much of the enemy, or in the meantime, while they're tied down fighting, you can, wear them out or attack them yourself. So when you're doing clandestine communications, you should always assume, it's always a good idea to assume you're probably already under surveillance, because then it forces you to make sure you're really doing everything right. But yes, using ham radio and then transmitting encrypted stuff, do not do that. That's actually against FCC rules. Would be a way to do it. But the ham radio thing, somebody can sit on there and record it right now and listen to everything that's out there. But here's the thing. Let's say you're a drug dealer and you're using ham radios. If I'm a police detective and I don't know you use ham radios, guess what? I'll never know what you're saying. But eventually I'm going to find out you're using ham radios, because eventually somebody's going to talk about it, or while I'm surveilling you, I'm going to notice that the, drug dealers are using a fucking Baofeng. And I'm like, oh, what are they doing? Oh, they're using short-range ham radios to communicate in a way, and then I can intercept all that shit.
Frequency mode.
Oh, we got it on. It's still holding charge like a champ. Let's see what's on the radio. So, there we go. So anyway, so ham radio is not itself secure, but there are other means to use it as a secure communication. For example, Nellie Orr in the Russiagate stuff, when she worked for Fusion GPS, she used a ham radio because there's no record of things unless you happen to be on there and recording. But nobody knew she was using it, so it worked. That's the biggest thing, is clandestine communications require, nobody know you're using it. But yes, ham radio is insecure. That's why world powers have number stations, yes. Only speak in Navajo codes. Well, yeah, that's the only other thing. You use a language nobody knows. But the government will be able to figure out what you're saying and what you're doing. Yes, you need walls within walls. J-Rock says Sean knows it's about time. I know about the secret Discord. It's because I know Ham. Ham is awful. Wait, your cheap Chinese radio batteries stay charged? Well, I don't know where I bought the extended one, but yeah, this has been charged for months. I turn it on every once in a while, make sure it works. And try to listen to stuff that's out there. Or, and like if the weather's getting bad, I'll make sure this is charged for the summer. I'll have Skywarn on here and just to make sure I hear it. I also have my county EMA is one of the presets. One of the PDs in the area does not use encrypted comms, so I do have them set as a thing as well. Never a bad idea to have a couple of presets. The commercial license allows encryption, yeah, but how many people have commercial licenses? Yeah, Pseudosnark says, well, if you listen to jail tapes, everyone thinks they got a code. Well, the problem is you have to be smart enough to have a real code. The thing is, though, generally they know who you are, who your friends are, and what you're doing. So even on The Sopranos, where they talk about the guy with the chicory or our friend, they talk in basic terms, but yeah, eventually if everybody knows. Yes, most people aren't practiced enough to use codes or stick to proper communication security. ComSec is a big deal, guys. If you want to learn stuff, go to S2 Underground. It's a great YouTube channel that will help you learn all kinds of shit. S2 Underground's really good with that stuff. So, real quick, we have some more comments here. Sleuthy saying the Taint team is still full of state actors, lol. Seems like they should rethink that whole process. Oh, I agree. They should be private parties brought in. Here's the problem, though, Sleuthy. You're going to bring in a private attorney. He's going to be like, well, fuck, how do I get paid? It's part of the issue here. And but yes, I think there should be a private attorney involved. But you got to find an attorney who's got the time and the ability. And if that attorney has time and ability, it might be your younger attorney, which you probably don't want. You're not going to get David Yanetti. He's not going to, I don't have fucking time. But we'll see. Yes, everything, and Sleuthy is right. Everything in Massachusetts does propel the idea they're crooked. Yes. This is actually a very common thing in the Northeast. The way governance is done, it's very crooked feeling. But to be fair, really, if you're in the 13 colonies from Maryland on up, it's all sketchy as shit. The way it's all done is very sketchy. The way all of it's set up. If you're in the South, it's a little different. Also, if you're basically out into the rest of the country, it's different too. But yeah, New England and the Mid-Atlantic, it's very not good. So. And KRM is saying Sleuthy has the best repository of Karen Reed documents. Yes, and Richard Allen documents. Great stuff out there. Mavka's saying Jackson Hinkle is based. Okay. I don't know what this guy, he's got to be the biggest fucking, he's got to be a glowy, because I don't know how he's doing all this shit. Jackson Hinkle is, he came on, initially he was like a communist grifter. He was he held himself out as being an actual communist. And he was like a communist and an American patriot. And he's jumped around in ideas and grifting everywhere. Well, this guy has now showed up in fucking Yemen. He's been to Russia before. He's now in Yemen. And this is him and in fucking Yemen. And you're just like, what the hell is going on with this dude? What is going on with bro? But listen to him.
Because the people of Yemen fear nobody but God. لأن اليمنيين لا يخشون شيئا إلا الله. I understand that here today, أتفهم إليكم اليوم. It is Quds Day, and I could think of nowhere else I would rather be than with the free people of Yemen. وأتشرف وأفخر بأن أكون في يوم القدس هنا في اليمن بجانبكم. As the United States drops bombs on the people of Yemen and Gaza.
So anyways, that's Jackson Hinkle. And he's fucking weird. But also, it's not as cool. I'm not going to lie. If you're going to go rile up a bunch of Arabs and a bunch of Muslims that are holding guns, the Shias aren't as cool because it's better when you go to a bunch of Sunnis and they just start screaming, Takbir, Allahu Akbar! Like, those guys are cool. The Houthis are Shia. So, like, when you get the Sunnis all fired up and they're just like, Takbir! And, like, and they're just screaming about Allahu Akbar, that shit is, like, I'm not going to lie, that actually is impressive. Those guys, that was boring as shit. That was boring. That was gay! That was gay. So... that was gay. Unforced Ego for $20. Thank you. $20 Doritos. Says, Nick is high as crap on biggest problem right now. Squirming, meth mouth, ceiling cats. He knows he can't be tested again until Monday. And he'll be out of his system. Sorry to interrupt. Well, thank you. I appreciate it. John Coleman is saying, not so fast, fat man. When is it part of treatment for a doctor to bang the patient? I don't know. Maybe if you're a sex therapist. I don't know. Do I look like a doctor? I'm not a doctor. And I will say for attorneys, bang your patient will get you disbarred. They warn you of that. And P-Dub is saying, Stringer Bell. Yes, Idris Elba has been out there in the press making statements that you need licenses for swords and knives because that yellow legal pad could give you a paper cut. Yes, sadly, that is true. That is true. Oh, Trump one says, I agree. I don't want either, I don't want Salafist Takfiri elements in my neighborhood or radical Sunni or Shia elements in my neighborhood. But I think it's funny to one of those crowds is actually more intense in their chanting than the others. And Tech Guy South is, do I look like someone with a plan? Let me tell you. Bamala says, who's this Arab lawyer? That doesn't look scripted. All the cows reacted so natural and honest. Well, they're just like, who is this white guy? And they're like, oh, yeah, America. Yeah, woo, yeah. So on Corpse Day, no, Quds Day, Quds, Quds. Al-Quds is the original name for Jerusalem in Arabic. So it's like Jerusalem Day, and it's something the Iranian government started to commemorate basically, we're so awesome and fuck Israel on top of everything else. So that's what it's for. It's basically in opposition to Jerusalem Day because I think Israel has Israel Day or whatever they have as a big holiday. So it's the opposition to it because, Iran doesn't like Israel. So, yes. Unforced Ego says, Houthis rise the level of enemy for this treason clause. I don't think so. Don't think so yet. I would say no. Yes, just ask any mesh operators. And Matty B says, yes, if you're transmitting directly, you will be fixed and found. Unless you're in a heavily communications dense area. That'll help hide you too. That's why the Taliban were smart. They transmit to a repeater sitting on a mountain and nobody would find them. Yes, the Taliban were phenomenal about this. They were phenomenal about their cell phone use. They were really good at limiting it at times. And also they were really good at being able to hide from thermal optics. What they would generally do is carry a wool blanket with them. And when it came time, they would throw it over themselves, kind of like Lord of the Rings style. And you have temporary thermal cloaking. As long as you do it right. They generally would carry it if they had a pack, they would carry it on the bottom of their pack so it stayed cool. And it was air temperature. Ken says, I'm not allowed to have a sexual relationship with a client ever, even if they haven't been my client for decades. Psychologists are 7 years no longer a patient. Wow. That's interesting. Yes, OPSEC and COMSEC are prophylactics. Have it before, use it, and then forget it. Yes. That's what people do. Oh, Brewberry says there's more than a handful of cases where the plastic surgeons bang their patients. Every once in a while, you're like, oh, where did that guy go? And you're like, oh, he's suspended. Those look like fake crowds. Well, yeah. The Houthis are designated as terrorists. Yes, so he could be charged with material support for a terrorist organization, but it wouldn't be treason yet. But that's why I think Jackson Hinkle is some sort of glowy. Something's going on with him. Something's going on with him. So. Yes, have I heard about the B-2 staging at Diego Garcia? Yes. Well, they did an airstrike on Yemen. They dropped some bunker busters, and apparently it didn't fully destroy the bunkers. So, some guy with cancer. Like I said, man, I hope you're doing well. Hope you're battling through that shit. Hope you're fucking crushing it. Really do. I hope you're doing well out there. You know, hanging out with Ric Flair, the nature boy, in his picture here. Says, did you read the decision on the motion dismissing Kieran's case? I did look through it. We didn't go over it live, though. It reminds me when I had to argue the world was flat, so the paper was all bullshit. Yes. Yes. Remember, judges will find a way to, if they want to come to a decision, they will make sure they can come to that decision. We talked about that. If, the Seventh Circuit case where they denied Bruin being in court, applying Bruin. If they don't want to, remember, judges can always say, I'm distinguishing that. It's different. Why? Because I said so. Judges are very good at that. And like I said, buddy, I hope you're hanging in there. Even high school teachers don't need to wait 7 years. Yeah, and you know what the interesting thing is? One of my high school teachers married a chick I graduated with. They ended up they ended up getting in a relationship later on, like years down the road. But it's still pretty crazy. Like, I don't mean in a bad way. I'm like, it's just weird. Like, I graduated high school with this chick, and now she's, married to the guy that was like my high school teacher at the same time. So, a little different. Bella says, member 15 months. Thank you for the support, Bella. Still cause for another Signal chat, in my opinion. Yes. Never a bad idea to have. Like, Signal's not bad. It's just you have to layer it. You need what are basically like white, black, and red comms. You need like white comms, you need black comms, then you need red comms. Like white comms you use all the time. Black ones when you're starting to try to be quiet. And then the red ones you have set up. You have networks in place that are set, tested, and used, but you never use them until it's time. And then when you have to use them, you use it. But nobody knows about it because you set it up in advance. So you have to layer your comms. Like you have red, white, and you have white, black, and red comms. Think about it that way. Layer them. And the red comms you never use until it's time. And then as you're using that one, you set up other networks. And you always have to be doing that. So no yellow comms though. Oh, you had a high school teacher left his wife. He got a girl who just graduated, who was in my sister's class. 10 years later, he left that girl for another girl who just graduated the year above mine. Well, I mean, yeah, once that starts happening, the pattern's been established. You can't have a shocked Pikachu face if you're those women. Did Elon just sell Twitter? I don't think so. Hold on. Let me see here. The Elon, it's not trending anywhere. Let me see here. No, I don't see anything. Huh. So, I wouldn't worry about it, guys. I haven't heard anything. So. Geez, my allergies are running wild today. I don't know what the hell happened. So. He sold it to... Really? He did? I thought I was doing a Pikachu face, but it's just a sneeze. Oh. Did Nick just do a line of cocoa? I don't know. He did turn the Ed Profit corner, though. Yeah. Trump once says, my friend's mother was a teacher and she had a relationship with a student. I never got any. Well. Sorry, guys. Had to blow my nose. That was bad. I heard USAID was totally shut down today. It does sound like that happened. Also, the Alien Enemies Act shit is going back up to SCOTUS again. So we'll be covering that there. And Lone Star Medic, you must also listen to Brush Beater, because I know he's the one who I learned all this from. Yes, the red side comms are the toughest because testing it may expose their existence and compromise it. Yes, but that's why like you have it done now, and then years later, it's kind of like quiet. But you don't have to do a whole lot to make sure they work. Am I wrecking lines as well? No. Oh my God, it's killing me. It's killing me. I can't stop right now. All right, guys, I think we're going to stop because I feel like my nose is going to fall off. Yeah, my allergies, yes. That tree semen is killing me. That's not yet, but yes, I will walk outside days and the cars are just fucking covered in yellow snow. It's bad. Will there be a model stream tonight? Yeah, we probably will do some model streaming tonight. Are you going to get hit with the storms this weekend? Supposedly we are, but I don't really know. We're going to, like, maybe, I don't know. Like, allegedly, yes. So, yeah, you've been a security guy in comms and op for a while. Managed to get grandma back 30K in Bitcoin by cracking their comms. Oh, nice. Nosy Rose says tree semen. Yeah, tree pollen. You know, it gets all the yellow just everywhere. So, Meme said you're going to play dinosaurs with him. Maybe one day. But yes, I think we're going to work on that, chat, because tonight we're going to work on something new. This is something we're going to work on here. And it is a tabletop thing I'm going to be working on with Wiggles from Crapcast. Bolt Action. It is a tabletop game where you like Warhammer, and you build dudes. And those dudes are things like, and I have the German side right now, and you get to build your guys who are all kitted up. And I don't know if they're going to be able to see them this well, but we're going to try. You get to have your guys all kitted up. You can, for example, you can make them, you put them all together, and you can also give them things like a Sturmgewehr, a G43. We're going to do a little bit of miniature figure painting. We're going to try and see how we get this to work. So, yes, dudes building dudes. Yes. We're going to come back probably in a little while to take a look at this, see what happens. But not right now. We'll come back, though. We'll come back. And, so. All right. So with that said, chat, thank you all for being here tonight, guys. The Karen Reed stuff did enough that we weren't able to get in the Andrew Tate lawsuit. We're going to cover that coming up here. Might do that Monday or Tuesday. It's a doozy. Andrew Tate is a whiny little bitch. So it'll be interesting from there. But guys, thank you all for being here. Twitter, Rumble, and YouTube. So chat, remember until next time, just because you did it does not mean you're guilty. Karen Reed, still not convinced she's guilty. I don't think I'll ever be convinced she's guilty. Turtle Boy, not guilty too. Good night, chat. And then Pseudosnark says, I'm going to pick the 3 all fall. Baby 2 comes in 1 week after it starts. Oh, well, good luck, man. Hope you get your courses. Where is Nick on tonight? He's on The Biggest Problem in the Universe. If you Google it, that's where you should be. That's that's Dick Masterson's and Vito's show. So, all right, guys, have a great night, and I'll see you in a little while. Take care, chat.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. What's that